Connolly. I'm from Flynn Business Lawyers. We're a specialist niche commercial firm in Dublin. We specialise in advising startups, small and medium enterprises, and one of the main issues that we would often advise startups would be on intellectual property protection. So I'm just going to talk a little bit and try not to repeat some of the stuff that Niall has very excellently gone through, but I'll just try to get some of the main issues that come up in relation to IP protection that might be applicable to startups or SMEs. So if we just take a look at IP itself, so just going back to basics, the definition of what intellectual property actually is. So it's basically the tangible or intangible results of research, development, teaching, or other intellectual activity. IP is basically a reward and recognition of your investment into some type of activity like this. So part of it, the clue is in the name, it is a property right, so just like any other property, it can be sold, licensed, transferred, or assigned. And particularly in relation to startups or young companies, it's often the main asset in the company. So whenever funding is being sought, it's usually, or quite often, especially in a tech startup, the main asset that any investor is going to look at, or it's going to be the main thing that will be investing in the company. So basically, just in this talk, I'm just going to run through some of the main types of intellectual property that we have in place, or like how certain IP can be protected. So we'll take first look at patents, which is probably one of the more hardcore IP protections. We all know that just protects inventions. And then just take a look at know-how. So this is sort of slightly different one. It more protects trade secrets, like the secret sauce in the business. It's not a registrable right, but it is a way of protecting certain information in the business. And then just take a quick look at copyright, because particularly for tech startups, this is what protects your software. This is what protects the source code. So it's a particularly important one to go through. I take a quick look at design rights. As Niall said, this is one that isn't utilised as much as it should be in Ireland. It's sort of like never thought about, or it's just seen as go for the trademark instead usually. And there is a slight bit of crossover between design right and trademark registrations. And then trademark is the last one, but I think I'll leave that because Niall has very excellently gone through it. So I suppose if you just take a look at patents first of all. So a patent is probably one of the more usual protections, IP protections we think of when we think of IP. So a patent protects an invention. The requirements for a patent is novelty is the first part, so it must be new. It must be like new in the state of the art. So whatever, particularly in this industrial field, the invention relates to this, it must have a certain element of novelty to it. They must include an inventive step. So this is usually defined as it's not obvious, or to an expert in the field, the invention wouldn't be obvious. And then finally, it must be capable of industrial application. So this is the sort of like just main basic requirements. Now there is several more. I know there's a few patent attorneys in the room, so I'm not going to like suggest that this is get your patent, that's it, good luck. So there is certain restrictions on what can be patented that you would need to look out for. Patented is a form of registrable IP. So as I talk about know-how, it's like different, but it's basically a registered IP right. It lasts, depending on the type of patent you go for, it lasts for up to 20 years. And one of the main elements that need to be considered, particularly for startups and SMEs, is the costs involved in the patenting process. Now, obviously, a patent will usually, but depending on the patent, it could well be worth all the costs that are invested in the patenting process. However, it is something to consider that it can be a costly process, and especially patenting, the patent, once registered, there is renewal fees after year 3 and onwards, so it's something that does need to be considered to some extent. Contrasting that with know-how. So know-how, there is some crossover here, so know-how can relate to both unpatentable information or trade secrets, trade secrets formula process, or it could be stuff that has yet to be patented. Know-how, unlike patents, is not a registrable IP, right? It's protected solely by confidentiality agreements, your NDAs, this type of like, this is the main way you go about protecting your know-how. Because of that, it can be cheaper to protect, but obviously it's more of a fluid right, or a more fluid way of protecting your intellectual property. If a patent can be put in place, or patent registration can be sought, it would usually be advised to go in that direction. Know-how, it's often as well usually licensed along with patents, so there may be some other information or some sort of trade secret formula that might be related to the use of the patent. It can often be licensed with the patent in practice. then just move on to copyright. So this is one of the main protections that SMEs, young tech startups, will be protecting their main asset. It's usually protecting the code, and copyright is how the software is protected in Ireland. As Niall said, it's an automatic right, so it's not registrable in Ireland at least, and the UK. There's no need to register it, it rises automatically upon creation. So there's no fees, usually no delays in protecting it. In the US there is some registration process that you would need to go through, so it's just something to be aware of when you hear about registering copyright. As well, copyright can be enforced as usual enforcement methods like infringement, like these type of ways of stopping an infringement of your copyrights, like injunctions, damages, etc. And there is international harmonisation of the copyright regime to some extent, so under both the Berne Convention, and there is something to a certain degree of standardisation throughout the EU. Just in relation to property to protection, so it's usually between 50 or 70 years from the death of the author, the original author, the second author, third author, which is joint authorship. So this is usually the main protection, as I said, that would apply to things like software. I'll just go specifically in relation to copyright. So copyright, it's the legal protection that gives the automatic creation of any original literary, dramatic, music and artistic works. This is how computer programs are better, but it also includes the traditional things what you think of when are protected by copyright, like authorship, works of authorship, books, etc. Websites, that type of property. And it's granted one distinction that is in copyright law that you might need to just be aware of is copyright protects the author, so the author will have rights, however the owner can be separate from the author. So like the rights in the copyright can be transferred, but the author may still have certain rights, your paternity rights, your rights to be identified as the author of that work. So it's something that needs to be aware of whenever you are transferring copyright, to make sure that those rights are waived to some extent. I'm just going to briefly talk about design rights. So as Niall said, this is a right that isn't often sought, at least not in Ireland. It's usually not thought about, or it's usually like, it's just basically people aren't as proactive in registering designs as they could be. Designs are usually used to protect the visual appearance only of the product. So this is the outward appearance of the product. There is certain requirements when registering designs, so sort of some similarities to the patent system, so it needs to be novel, and so this would just basically mean that there's no identical design already made available to the public. There would also need to be an individual character, so this would just mean that in assessing a design's individual character, you would need to see whether the overall impression that the product gives is different to any other product that is already out there. In relation to registration, as I said, design is a registrable right, so although there is an unregistered protection, I'll just go into that in a second. So you can register this with the Irish Patents Office, or the UK, or the EU Intellectual Property Office. There is just an unregistered design right. Now this is a separate design right, you don't need to register it, and it's usually used, although not always, usually used for protecting things like clothing. It lasts for 3 years, and it's usually used in circumstances where, for instance, the clothing industry, where a certain design really is no point in protecting maybe a certain item of clothing because it will be out of fashion by the time a registered design right went through. So this unregistered design right arises automatically, and it can be enforced. The more famous case, I suppose, you might have heard would be the Dunn Stores and Karen Wilson case. So that was in relation to unregistered design rights. I suppose just in relation to protection, the unregistered design right is usually 3 years. The registered design right can be up as high as 25 years protection in relation to how long it can last. I'm not going to talk about trademarks too much because Niall's pretty much gone through it all. But as I said, it really is applied for brand protection, and it's definitely one of a significant right to be sought after when you are seeking to build up and protect the brand. Finally, I'm actually just going to conclude on this part because there's one element, particularly for young businesses and startups, that does need to be considered when we are talking about IP protection. That's ownership of IP. And particularly in a business, the question always arises, or at least we see in practice, is, well, who actually owns the IP? For employees, the default position in Ireland, at least, is that the employer will own the intellectual properties. This is even if there is no employment contract in place. Now, we would still always advise it would be an employment contract in place. An employment contract will reaffirm this point that any IP created by the employee in the course of their work would belong to the employer. But it will also include other protections, for instance, obliging the employee to sign waivers if the employer needs to file patents. It can just ease the process. Also, simply from an employee management point of view, it lets the employee know that they mightn't be aware that automatically IP created by employees will vest or be assigned to the employer, so it's just something to keep employees happy and up to speed with what would happen. Contractors, however, treated differently, and this is a particular problem often for startups who tend to have a tendency to take on independent people or contractors to develop certain IP for a project. Contractors, the default position is it's an independent contractor. The contractor will retain the intellectual property. So this is something that will need to be covered off as part of a contract or an agreement with that contractor, that any IP in the materials or work that a contractor develops will be assigned to the employer or startup, the young enterprise. It's something that does need to be covered off, and in particular where you're seeking investment or where an SME or a startup is seeking investment, one of the first things they'll ask, if IP is main asset, is our IP agreements in place? Has the ownership trail been put in place to identify who exactly owns the IP? I'm actually going to conclude there, hopefully just about in time. If there's any questions, or I can come back later, I'll drop around business cards if needed. Thank you very much.